Stoneham v. BARSUK.
Chief Judge, I'd like to reserve 3 minutes for rebuttal.
Yes, sir.
It please the court. My name is John Lipsitz. I represent the plaintiff appellant Mark Stoneham. He seeks reinstatement of his claim under Labor Law 240 sub 1. At the age of 57, Mark was injured when the trailer under which he was working collapsed and crushed his pelvis. The key point of difference separating plaintiff Stoneham's 240 sub 1 claim against defendant BARSUK from whatever hypothetical claim a garage mechanic might have against the owner of the family car brought in for regular service is that defendant BARSUK owned the unsafe premises where the injury occurred, owned the trailer which collapsed upon and injured him, Stoneham.
Counselor, somebody bringing their car in for maintenance that would be put up on a lift in somewhere like Meineke owns that vehicle as well.
That's right, but that person would have no expectation that she would be cast in absolute liability for being responsible for maintaining a safe place of employment.
Would they have that expectation after a favorable result for you in this case?
Absolutely not.
Why not?
If a favorable result in this case, based on the facts in this case, would not open up the floodgates of claims for such things as claims by the mechanic at Pep Boys or Midas Muffler against the family car, the person with the family car bringing in for service.
What about against Pep Boys or Meineke?
Or against Pep Boys or Meineke, for that matter, and
What's
it's
the
probably workers'
distinction
comp bar.
there?
And
What's the
that's-
distinction
that
there?
instance.
What's the distinction there then?
The distinction between my client being injured at the BARSUK scrapyard and the person at Pep Boys being injured, or rather having a claim, the mechanic, if the car falls off the lift and falls on him. Well, certainly I don't
Claim
think.
against the owner of the shop.
Well, I mean, there may well be a claim for negligence or a claim
The
for
question
workers'
is, why is it
compensation.
not why is that not a Labor Law 241 claim where this one is?
Well, that's not a Labor Law 240 sub 1 claim because we're talking about a workplace which essentially is similar to the manufacturing facility in Dahar or in Preston, where you've got a regular workplace. People come in, they punch the clock, they work shift work, they do things repetitively. It's a service-oriented business. It has more to do with Dahar and Preston in that regard.
I'd like to counter to you that that's more like a Labor Law 241 claim, because at least at the Meineke or the repair shop, they're actually in the business of lifting cars up at a height and creating that unique sort of risk that's incurred when you're dealing with elevation differentials. This was, obviously there was an elevation differential involved in this case too, but it was a rather unique set of circumstances that brought it into existence.
I would say it not only was it a rather unique set of circumstances, but when you have the Midas Muffler situation, you've got lifts that are used dozens and dozens of times a day. They're designed, situated, and posted in the ground. They're time tested.
And one would hope that would be done for the purpose of the safety, not just of the people who own the car, but for the people who work on the car as well, wouldn't?
Well, absolutely, but
How is that not Labor Law 241 at Meineke?
under this court's decisions in Dahar and Preston, and I think under a common sense approach, I don't see that a decision upholding or sustaining my client's 240 sub 1 case would spill over to the Meineke Muffler
But why
situation.
not? Why would it not have that effect?
Why would it not? Well, essentially, garage work, it's done indoors in a regulated, routinized setting. It's akin to the routine cleaning and assembly processes occurring in the regular course of manufacturing products in a factory setting.
Okay, so let me give you a different example then. What about, have you seen outdoor parking lots where cars are stacked up and, right? So now we're outdoors. Now we don't exactly have a routine. It's not manufacturing. Car slips off one of those and hits the garage, the parking attendant.
Well, Your Honor, you could posit any number of
And I
scenarios,
will if I have to.
okay? But the scenario we're dealing with here, and that's where I started my argument, is Mr. Barsuk owned the scrapyard, it was unsafe. He owned the trailer, which was a massive object. He owned the front end loader, which in a kind of jerry-rigged sense was used to lift it up. And he also owned what he claimed were the logs or the timbers and pieces of metal that he sort of ridiculously or absurdly argued could have been used to
But
keep the...
all those things would have been true of my parking lot owner too. So what we're still looking for, I think, I mean, I don't want to speak for anybody else, is why this doesn't spill over to other situations.
Well, I don't suppose that when you're taking your car to the parking lot in Midtown Manhattan and you're going to a show and you're leaving it with the parking attendant, that you have any reasonable expectation that you're responsible for the safe operation of the parking lot or the machinery that's used to elevate the car.
No, of course. No, the claim is not against the owner of the car. The claim would be against the owner of the parking lot, right, by an employee of that lot for a car falling off of a 3-high lift.
The floodgates argument raised by the defendant in this case has to do with the ownership of the structure, namely the vehicle that's brought in by the consumer. I can't speak to the question of whether there's some liability on the part of the owner of the parking lot and the parking lot attendant. Clearly, there's liability for negligence unless there's a workers' comp bar involved between the two of them. So I don't see
A little
how-
bit,
the absolute-
somewhat different question along the same lines. Did Mr. Stoneham work for the owner of the structure or the owner of the location where the structure was located?
Well, yeah, our claim is that he was employed within the meaning of that word for 240 sub 1 purposes by Mr. Barsuk. But he did, if your next question is, did he bring a claim for a workers' compensation benefit?
No,
he did not.
No, I'm really interested in the nature of the employment relationship. In this situation, correct me if I'm wrong, Mr. Stoneham undertook to do the work on that thing, whatever it is,
It was a trailer, probably.
a trailer, in exchange for like some kind of loan forgiveness.
Yeah, he had approximately 3 months before, Mr. Barsuk had loaned him $5,000, I'm sorry, $25,000, and the understanding was, according to my client's testimony and his affidavit, which is totally consistent with his testimony, that he would work off that money, or some of that money, by providing labor. In other words, he was obliged to provide labor in order to meet his obligations.
At another point, didn't he also say that he intended to pay back that loan in full?
Well, that's ambiguous at least, because the point in which he said that, it was just easily, it could have been interpreted as in addition to the work that I've done to pay it off, when it comes time for me to settle with him, I'll make sure he gets all his money back. But he did say, and he was asked, well, is Mr. Barsuk keeping track or someone keeping track of the work you're doing and debiting against what you owe him? And he said, yeah, Mr. Barsuk was doing that. Now, Mr. Barsuk put it in an affidavit. I don't believe the affidavit flatly contradicts that, but Mr. Barsuk's never been subject to any kind of cross-examination. It's simply his affidavit.
Well, how do you,
It's a clash.
How do you deal with your client's testimony that he was not an employee, he was not an independent contractor, he wasn't an employee of the recycling plant or anybody having to do anything with the Barsuk family? It's under oath. I mean,
He also testified that he had borrowed money and that he was doing work at the scrapyard on heavy equipment to pay back Mr. Barsuk for that money that he borrowed.
Go back to Judge Singus's question for just 1 second, but I don't get that it was ever anyone's expectation that Mr. Stoneham was going to pay off the entirety of the debt through labor. My understanding, please correct me if I'm wrong, is that he knew he had a debt, he intended to pay it back, but he wanted some credits to the debt by doing occasional things around this yard of Mr. Barsuk's.
I think at least from Mr. Stoneham's testimony and from his affidavit, it's much more formal than that. It's much more an understanding and a clear, concrete understanding on Mr. Stoneham's part that When he got up in the morning and went, well, actually, he went to the scrapyard 3 times to work on the trailer, once at the end of July, once on August 4th, and once on August 18th. He said, I didn't get up out of my house, drive all the way to the scrapyard, do all this work on the expectation, because it was a volunteer. I was expecting that this would reduce my indebtedness.
So if it was more formal than that, was this reduced to a writing?
No.
Did he do it every day?
No, he was an occasional worker for Mr. Barsuk's scrapyard. His regular employment was at a paving company. And he worked over the course of some number of years. He said he went in and out of the scrapyard, the Barsuk businesses, to do this kind of mechanical work.
And were they
on
keeping
heavy
like a
equipment.
log of how many hours he was working to,
No,
how much he was being paid off and how that would set off the loan that he
there's
received?
no
No
formal
formal.
accounting in the record. But the trial court did find that there was an issue of fact to be determined, to be resolved by a jury with respect to whether he was an employee or a volunteer. At the Fourth Department, I think the majority basically didn't deal with that issue, but the 2 dissenting justices said, yeah, there's an issue of fact here. And in fact, the trial court read the proper authorities, the cases are, one of them is a Court of Appeals case, it's the Stringer, I think, and read the appropriate appellate division authorities, looked at the facts, looked at the testimony, looked at the affidavits from both parties, and concluded that there was an issue of fact that had to be resolved by a jury. So with respect to that issue, as we put in our brief, and with due respect to the court, I don't think it's before the court. It's certainly not any kind of plain error on the part of the trial judge who said it's an issue of fact to be resolved by a jury.
Thank you.
But if I could go a little bit further with respect to the things that distinguish,
Did you say rebuttal time? I've forgotten.
I saved 3 minutes.
Okay, we'll hear you then, and we'll let you go a little longer then if we need to.
Thank you. I'll sit down.
Yes.
Good afternoon, Your Honors. James Special for Mr. Barsuk. First thing, I should point out on the point that my client wasn't deposed in this case yet. That's because plaintiff moved before they deposed him, so that's why that seems to be, that I thought that was a strategy of some kind, so I'm not sure that that hurts us at all. But with respect to the point about he's a volunteer, I think as Chief Judge Wilson pointed out, he's clearly asked, were you ever an employee? He says, no. Were you ever an independent contractor? He says, no. My client also says that in his affidavit, there's no records, there's no...
What about the claim that they traded off services and he was trying to pay down a debt here?
Well, I mean, to me, I find his testimony that he's going to pay back the full loan weird in light of that, because you're paying back money he doesn't owe, right? And also...
Well, he says he's paying the loan in full. That could include having done work that is then credited towards the debt. He's simply saying, I'm not going to cheat on my debt. I'll pay it in full. It could be through cash payments. That could be through service. It could be through both.
Okay. Yeah, even if you read it like that, we had asked him to list the jobs that he had done as part of working off this debt. And he gives a list, and when during our questioning, he doesn't say this. He says other work. So he was given an opportunity to just say, yes, it was for this.
Let's take for granted that he said things that are contradictory, right? Some would suggest that he is an employee and some would suggest he's not. Why isn't that an issue of fact? The jury gets to assess his credibility. Maybe they agree, he was lying one time or the other.
Well, because I don't think it's a legitimate dispute of fact, because I don't think it's enough for him to say, in my mind, I was an employee or I was paid, because that, to me, that sounds like almost like a statement you would see in a pleading that's done.
He doesn't exactly say that, though, right? He says, he testifies, I was not an employee, I was not an independent contractor, but he also says in an affidavit that he expected to be compensated for the services he provided. And you might understand how a layperson would think, I did expect to get, pay down some of this debt by providing some work for this person, but I don't think of myself as an employee. But the layperson might not have an understanding of what it takes to be considered an employee under New York law. I mean, he's not a lawyer.
Sure.
So maybe there's an issue of fact there.
But I would say on that, what I would go back to is when we asked him, okay, what work did you do to pay off the loan? He lists out things, but not this. During his deposition, it certainly seemed like this was not, and there was no question this was not, until the question at the end when he says, in my mind, is how the question was phrased. So I would go back to when he was asked very clearly, okay, tell us what jobs. He lists them, he doesn't list this.
He also says Mr. Barsuk was keeping track.
He says that, and in my client's affidavit,
He doesn't say I wasn't keeping track.
sure, but he wasn't, if the issue is that, he hasn't been subject to cross,
Was the $25,000 a gift from your client?
no, it's not a gift. It wasn't a gift for,
So he did expect repayment.
sure. Yeah. Turning to the issue of the structure or the trailer, I don't see why it wouldn't apply to Pep Boys or any other type of business like that. There too, you would have a car on a lift. If a piece falls off, I don't even think it would need to be the full car falling off that would trigger 240. A piece could fall off. I don't see why it wouldn't.
One reason why it might not apply in that context is under 240, the liability runs to the owner of the structure, right? Which I guess in the Pep Boys scenario is the structure is the car that's been brought in. And it would seem to me, and forgive me, I'm sort of thinking of the exclusion for 1 and 2 family homes here, but I would think there'd be some kind of exclusion implicit in the statute that would make the owners of cars not liable. Maybe.
I would say that I hope that it could be read that way, but I don't think it can now because,
Instead of just hoping, would you look at the legislative intent instead?
yeah, right. So there's nothing in there that I've ever seen to suggest that says it should apply to car repair work. And when you look at the statute itself, it says the single family dwelling. So if this court were to rule, yes, it applies in this case, and therefore it would apply to cars, I don't think tomorrow everybody is going to be saying, oh, well, there's no issue for every car owner in the state. I think there's a real concern that ordinary car owners like you and I, let's say when you're driving back to New York and you get a flat
Can I
tire.
ask you, counsel, how do you distinguish Caddy, the railroad car case? Is there something different about a railroad car from a regular vehicle, and how does the trailer bed here fit in there?
So, right, so the railroad car, it runs on rails, so it's not in the category of a vehicle that we're talking about here.
In the category as defined where? In the VTL?
Right.
And so you'd have us import that definition? I'm trying to understand how we square Caddy with your view.
Well, and right, so, and I think that's what the 4th Department did, is they didn't say that this wasn't a 240 case because the trailer was not a structure. If they did, then I think Caddy comes into play.
So you think it is a structure?
Under the definition of Caddy, or in Caddy, it would be because anything.
And why is it not covered?
Because vehicle maintenance, given that he was in, well, there's two parts to it. Vehicle maintenance isn't covered under 240. I've never seen anything in the legislative history.
Structural repair is covered under 240, right? So if this is a structure vis-a-vis Caddy, and the work being done is more akin to a repair than maintenance, that's it. 240 applies, or am I wrong?
If it's a repair of a structure, no, because not all repairs of structures are 240 cases.
So what's the missing ingredient that takes it out of 240?
He was involved in his ordinary occupation of being a mechanic, which is why I cite two cases like Miserati, right? Because in that case, that plaintiff was also seriously hurt, but there's always going to be a risk when you're a construction worker of a wall coming down. And the same is true here about, like at Pep Boys or the same type of business. Every time anyone gets under the car, there's always a risk of the car itself, or a piece could fall. So if all that's necessary is that if it can only be based on a repair of a structure, then I don't see why there would be a concern about 240 coming into play in all these, for businesses like Pep Boys or similar. So I essentially think that's too narrow. I think
So you just reminded me of some other thing when you talked about the lift. At Pep Boys in Meineke, they have these really nice steel hydraulic lifts with, those poles that go into the floor. Here there was an earth mover that was used to hoist the what your adversary claims is a structure. Is there any argument with respect to, 240 provides for the provision of certain devices when you're lifting a load, Is there any dispute on your part that the device provided was adequate to the task, or are you sort of ceding ground on that one?
So the bucket he was using at the time, clearly it didn't work, and it's not something that's ordinarily, I would think, used to lift things like that. Why he didn't use the fork that was used the prior time, we don't know.
But all those things do belong to your client. The bucket, the fork, the machine itself, those all belong to Mr. BARSUK, right?
Right.
Yeah.
So really what I'm saying is it's not just a repair on a structure. That's too narrow of a view to just require those two things. I think, as this court often has in the past, you have to look at the nature of the work, and if it's an ordinary hazard of the workplace. And here, I would say it is, because anytime someone like Mr. Stoneham gets under a car, there's always that risk. And I would say that would be why a situation of Pep Boys, people wouldn't ordinarily think of it as 240, but if it's not 240 there because it's an ordinary risk, it's not 240 here because it's also the same risk of people who do the same job as Mr. Stoneham. If there's nothing else, then I'll sit down.
Thank you.
I'm going to use my 3 minutes as efficiently as I can. That is the risk. The risk that 240 sub 1 deals with is an elevation-related risk, and this was a falling object case. And if you say this was his ordinary work, and because his ordinary work was getting under things to fix them, and they can fall on them, then you're going to eviscerate the statute altogether. And by the way, this wasn't his normal employment. His normal employment was at a paving company. Judge Wilson, you said perhaps he would understand the word employee in a different way. Well, yes, he was employed regularly at a paving company. That's where he went to work on a regular basis. He didn't go to the scrapyard on a regular basis. And as far as Caddy's concerned, I think more to the point is even Gordon, the other railroad case involving the sandblasting of the railroad car. There, the court said, what's really important here is that the defendant owned the rail yard. And that's why because the defendant said, well, I didn't own the rail car, but you owned the rail yard, and that's where the unsafe activity was taking place.
Counsel, what do you do about Dahar? Dahar says that while this court hasn't held that labor law only applies to work performed on construction sites, that the central concern was dangers affecting workers in the construction industry. And this is obviously not that setting.
Your Honor, if you go back and you look at Caddy, Gordon, Jahar versus Jablan versus Salo, all of these cases say the central concern is that there be a safe workplace. This court has never privileged traditional construction sites over non-construction sites.
Dahar certainly says that the primary concern is construction sites.
Well, Dahar says that, but it's not terribly in sync with the 100 years of jurisprudence preceding it, which was rooted in an examination of the statute at its very foundation. And I'm talking about Caddy, which is clearly not a construction site case, and that was the first
But in
case.
Counselor, in Caddy, I'm looking at it right now, and one of the conclusions is, it justifies a further conclusion that the temporary support which surrounded it was a scaffold. So they brought it into the scaffold law very directly here.
Well, Caddy was primarily concerned with this question of whether a structure was some kind of a subset of a building. And I think what Caddy said was it says structure or building. And when you talk about the scaffold, I mean, if you want to look at our case, you can look at the trailer essentially as being a scaffold which collapsed on a worker. I mean, it's something that people walk across, and he happened to be underneath it repairing something, and it was held up about 5 feet above his head, and then it crashed on him. And just one other thing that I think is important to bring up, that this scrapyard was so unsafe. There was evidently no emergency plan. My client was pinned under that trailer for 5 hours before anyone came to see him. And it was BARSUK that ended up finding him. The thing was fenced in, it was isolated, it was filled with construction equipment, pieces of debris, logs, pieces of metal objects. It was not the regular kind of routine that you'd find in the Pep Boys, you know, with the 3 bays and the 4 bays and those beautiful hydraulic lifts, which, by the way, probably there'd be nobody's gonna be hit by a falling car there unless it's the result of improperly positioning the car on the lift in the first place. I wanted to bring up just 2 cases and to demonstrate how there's no evidence and there's no possibility of some kind of floodgates. One of them is the case Cornacchione versus Clark Concrete. And there, the court found that a person engaged in painting the name of a company on both sides of the boom of a large crane, that person was engaged in working on a structure. And a crane, by the way, as we pointed out in our brief, is a vehicle. And there's also Moore versus Schulman. Let me get back to that. In the dissent in Cornacchione, there was in the majority was Justice Piggott, and he was also in the majority of Moore versus Schulman. But in Cornacchione, the dissent said, gee, I'm worried that this is going to open up the floodgates, and every time someone brings the family car in to be painted another color, if somebody falls off the step stool painting it, they're going to sue them under 240 sub 1. Now, it's never happened. I mean, it just didn't happen. It didn't happen after Moore versus Schulman, where they're converting utility vans into cargo vans. Nobody came in later and said, God, somebody hired me to convert my car to a hot rod and a piece
One
of...
more point you wanted to make because you...
That's it. I'm done. Thank you very much.